Any mention?
Your Lordship, I'd like to mention item number 13. Lordship, Miss NG Sheila is the conducting counsel here and she's on sanctioned leave, Your Lordship.
Lordship.
When?
After 2 weeks, Your Lordship.
Okay, this on the request made on behalf of the state respondent. State respondent.
Yes, Your Lordship. 1, 2, and 3.
List is matter after 2 weeks. 2 weeks. You are for? Oh, yes. Please record.
Obliged, Your Lordship.
Please, Lordship. This, I beg to mention the item number 4, Your Lordship. Since the record has come, I just need to examine the record itself.
Yes.
No objection.
No objection. When? After 2 weeks.
After 3 weeks, Lordship.
Okay, item 4.
Lordship.
Private respondent.
Respondent number 4, Your Lordship.
Just record this. On the request of Lord Counsel for the petitioner. List after 3 weeks.
Lordship. First place, Lordship.
Your Lordship, may I beg to item number 2.
Yes.
This is the matter regarding this compensation appointment, and I supposed to have some instruction in the matters, but not yet received, because there was ban in recruitment. So not yet any information has come.
What instruction you really want to?
My lord, whether that ban.
Ban has been.
My lord, there was a notification by the Ministry of Home that banning, since they have exceeded their recruitment, my lord. So they say that no.
Exceeded means there is a quota for compassionate over.
Compassionate appointment.
Fixed quota.
Yes, ma'am. And the ministry has said that you, if at all any other is there, you can send a proposal to us. So we will consider your proposal. So what is the outcome? Until unless that ban is, what is the proposal they have sent? The list which they have given, my lord, there is also a 58 years of age person is still waiting for the appointment, my lord.
See, this is a 2018 matter compassionate appointment. What
My
purpose it would be served?
My lord, since the
Purpose it would serve, just tell us.
purpose will be served, my lord, until unless that ban is not, or what is the proposal sent by them, my lord? If it will linger till
If you can survive for so many years,
my lord,
without being appointed, then it is implied. Anyway, just say, Mr. R. Devnath, London Council appearing for the Union of India. London Council appearing for the respondent. He submits that some instruction is required to be obtained in the matter before the matter is finally taken up for disposal. Mr. Archer, London Council appearing for the petitioner has no objection. Period allowed. List after 2 weeks.
3 weeks.
3 weeks, such a long time.
Just,
Okay, list after 3 weeks. List after 3 weeks. But then don't take, see, this kind of things, why should we keep it pending?
Now only this matter for the instruction regarding whether proposal sent with the unit, whether it is considered or not.
Okay.
whether the ban has been lifted or not, my lord. If it is
You
not,
have that instruction.
my lord.
Anyway, it's okay.
Please, Your Lordship. Your Lordship, I beg to mention item number 15, Your Lordship.
15.
On behalf of the number
15 and 16 are connected, Lordship.
Yes, my lord, they are connected, 15 and 16.
16 also you are appearing.
My lord, 16, Miss R. Colony is appearing.
this matter can be taken up after 3 weeks, Your Lordship.
Any objection? No objection. Okay.
My lord, a stay has been granted in this matter.
No objection,
In
madam.
item number 16, there is an interim protection granted to
objection.
the petition.
Senior counsel is leading this matter, my lord. She has been informed. She has no objection to that.
Let it come after 3 weeks.
So you are having contradictory objection. Huh? Anyway, 15, 16. On the request made in behalf of the petitioner, release this matter after 2 weeks.
Oh, this respondent number 2, Your
Oh,
Lordship.
acha, on behalf of respondent number 2. See, respondent is asking for time. So what is the problem in there?
My lord.
Yes. On the request made by the respondent number 2. This is matter after 3 weeks. 3 weeks. Okay, 3 weeks.
Obliged.
Should be obliged.
Obliged, Lordship.
May I beg to mention item 3 of the hearing list, Your Lordship?
Yes.
No objection.
She has not made her submission. See, how do you know what objection you will have objection or not?
Your Lordship, I am praying that this matter.
Visa, which says it was up to 1710. What is the document, Mark? What is the document?
It is before your lordship. I have produced that material exhibit before your lordship.
Yes, so what is
It is in the record of the court.
There is what is marked as exhibit? What?
Exhibit. It's a material exhibit. Material exhibit.
What is that? Material exhibit what?
Material exhibit 1.
And what about the fake one?
It is in the same.
Okay, same document.
Same book. It's not a separate document, lordship.
Okay. The extension is on the same document.
Yes, passport and visa, they are in the same book, not the separate document.
And you said the seal is fake.
Yes.
That is your contention.
Yes, Lord. If you compare, lordship, the seal in the second extension, lordship, you'll see that the letters are
The
bigger.
trial court has compared it and exonerated him from the charges of this thing.
Lordship, the thing is that.
What was the other section you were charged under?
My lord, 469 and 471, my lord.
So 469 and 471 you were exonerated.
My lord, I must.
Why he has been, the lordship, why he has been.
469. How
469.
How 469 comes here?
Forgery for the purpose of 468, my lord.
So not 469. That is what. 469 will not come here.
468 and 471.
Lordship, this act of forgery, lordship, it was not committed by this petitioner. It was committed by another person who.
Does the finding say? Whether the finding of the trial court say?
The evidence is there, lordship. From the evidence.
What is the finding of the court?
Finding.
What the court says with regard to the forgery?
Lordship, I'll take your lordship to the judgment.
Just take us to the relevant part.
Yes. There are two issues framed by the court, lordship. One issue is this, and is regarding section 14.
Where is that? Which
number
page?
2 is with regard to forgery.
What page?
Page 73. Page 73 of the paper book, lordship.
This is a part of the judgment.
Yes, page 73. Points for determination. Issue number 1 is points for determination. Page 73, Lord.
Yes.
Issue for points for determination. Point number 1: whether the accused person Shri so and so being a Nigerian national remain in Indian territory without valid visa and thereby liable under section 14 of the Foreigners Act.
Yes.
And point number 2: whether the accused person Shri Godfrey Albert Decker forged the visa with the intent to cheat and thereby liable under section 468. And point number 3, whether the accused person, Shri so-and-so, used the forged visa as genuine, knowing and having reason to believe that the visa is forged and liable under section 471 IPC. Point number
What is
2,
the issue number 2 and 3? He has been held not guilty.
issue number
2 and 3, he has been held not guilty, isn't it?
issue number 1, Lordship. Issue number 1, section 14, regarding section 14.
Kindly try to get this thing.
Oh, yes, sorry, yes. Issue number 2 and 3, Lordship. Yes. Issue number 2 and 3.
He has not been held guilty. He has been exonerated.
Exonerated, yes.
Okay. Now, then remain issue number 1.
Issue number 1.
And the issue says that whether accused so and so, being a Nigerian national, remained in the country without valid visa.
Yes.
So, on what basis could come to conclusion there was no valid visa?
Yeah, it's come to Lordship. I'll take your Lordship to this.
Just give us, tell us, take us to finding with regard to issue number 2 and 3.
With regard to issue number 2 and 3, Lordship.
Yes, let us first see.
Page 77.
Or which one was decided first? Issue number 1 was decided first.
Issue number 1 was decided first.
Without deciding issue number 2 and 3.
Issue number 1 was decided first at page 73. Issue number 1.
Well, just what is that? 2 and 3. Issue finding on 2 and 3. Where it is?
Finding on 2 and 3. Finding on 2 and 3 is page 77, Lordship.
It's not a big judgment. Yes.
Page 77. Issue number 1 and 2 are clubbed together and discussed for convenience.
Okay.
This court perused section 468 IPC, which lays down as follows. Section 468 IPC, forgery for purpose of cheating. Whoever commits forgery intending that the document or electric record forged shall be used for the purpose of cheating.
Just keep 18 keeps. Just read from 20.
Okay, paragraph 20.
Yes.
On examination of the evidence, this court found that PW6 in his evidence deposed that PW6 did not make effort to trace the name of the person called Celestine as accused, did not mention that Celestine is from Shillong, and neither gave the address of Celestine. PW6 deposed that Mr. Celestine may also be the accused person as he was named by the accused in his statement before PW6. But accused person is also equally involved in the case as he must be knowing that such person is involved in making fake visa.
Who is Celestine?
Celestine is the person, he is also a Nigerian. After that he has disappeared to...
No, who is he? What for he is, I mean, what role he had in this matter?
He is the person named by the petitioner who helped him to obtain the visa. There are many, these type of people, Lordship, who obtain visa for...
So Celestine was not traceable in this?
He's not, he has disappeared.
Was he made an accused in this matter?
No.
He is not made an accused.
He is like a agent to...
But then was he, say supposing if the petitioner had availed his service for getting his visa extended.
Yes.
So that means he had a hand there, so he has not been made an accused.
He has not been made accused because
so
he has
whether
disappeared.
he is absconding is not there is none of your concern if he is not accused.
He has disappeared, he is also Nigerian.
Doesn't matter, you have not made him accused. If he disappear also, what is the problem? He is not an accused. If you do not make him accused, why should you say he is disappeared?
But the finding of the court is that the forgery was not committed by this petitioner. So he has been...
Where is that?
I'll read further, Lordship. 21. Paragraph 21. From the evidence, it reflects that the material exhibit, which is the passport of the accused person, is genuine. However, the visa at page 5 of the passport is found to be fake. The evidence adduced by prosecution shows that the accused person left Shillong for Guwahati on 12/9/2011. The evidence shows that when the accused person was asked to report in the office of the FRO Shillong, where he appeared and his statement was recorded, the evidence of PW6 shows that the accused person mentioned the name of the person who helped him with the visa extension. However, the prosecution failed to examine the person who assisted the accused person in obtaining the visa. The prosecution, through the FSL report, Exhibit 5, proved that the visa is fake. However, the prosecution failed to adduce evidence to prove that the accused person forged the visa or had knowledge that the visa is not genuine but fake. Issue number 1 and 2 are decided in the negative and in favor of the accused person.
The court found that the document is forged.
forged, but it was
But
not
then
committed by the
could not
petitioner.
come to a conclusion that
It
the
was-
petitioner has done it.
Yes, Lordship, that is the case. So acquitted him and convicted him under Section 14. Under Section 14, a case is there, Lordship. He has overstayed. He has overstayed the period exceeding his visa. I'll not go to other evidence, Lordship, the FCL report, the fax message from the authority who's looking after this issuance of visa and all. From the embassy, Lordship, from the embassy. All these things points the needle to the, they are against the petitioner.
Now, why then, if court found that this visa is fake, how could this accused be exonerated of that charge? See, it is not required for him to go and do it by his own handwriting. The purpose is for giving benefit to him.
Yes.
Isn't it? Now, can these two findings stand together? Once you say that he had no role, the person concerned who has procured the benefit of that forged document, his role is not established. But then you say you say that it has been forged.
Yes.
Then for whose benefit it has been done?
He benefit of this petitioner only. He is the beneficiary.
But then you have
Lordship.
exonerated him. That is why whether these two findings can stand together. Moment a court comes to a conclusion that is a document is fake.
It's fake.
And when it is apparent that it is forged with purpose of, giving benefit to the accused, then in such a case, how come accused be exonerated?
Yes.
Or you have not challenged that finding.
No.
Then what happens in this situation?
That is my humble submission is that, Lordship. The court has.
Can you give us something that in such a situation that the finding with regard to the genuinity of the document would remain? Genuineness of the document would remain.
Genuineness
of the document. Two things here. One is that court has held that this document is fake.
It's fake.
But then could not say that the accused has committed the forgery. Exonerate the accused.
The finding of the court is that
if you see the document,
Yes,
it is solely for the purpose of giving benefit to the accused.
Yes.
Then what happens? Then what is the consequence of that finding then?
Actually, Lordship, he should have. He did not himself go to the FRRO office for obtaining the extension.
It's okay, but then somebody has done it at his instance. So in such a case, he will not be.
No, he should himself go to the FRRO office. He should report to the FRRO office for extension, Lordship, himself, not by any other person, because there they'll have to verify everything, Lordship. They'll have to verify his all the details, Lordship. But he did not himself go, so he also is involved. It's like he's involved, but he just asked another person to get it for him.
No, then if you say he is involved, then why you have not challenged his acquittal?
Acquittal.
At least his this thing discharge from this, or rather, yes, it is not discharge. His exoneration from these charges.
It is not there. It was not.
You yourself have not challenged it. Now, what is the consequence of this kind of finding? Document is found to be fake.
Against this judgment, Lordship, the petitioner has filed an appeal before the Learned Appellate Court. It was affirmed. This judgment was affirmed by the Learned Appellate Court.
Where is that judgment of the Appellate Court?
It's at page 89, Lordship. Page 89.
Page 69.
89, Lordship.
89. This is a revision.
Criminal appeal. Criminal appeal.
This is a revision, isn't it?
This revision, yes.
What is the sentence?
Sentence is 1 month and fine. 1 month and fine. Fine of 5,000 fine.
Okay, what is the finding of the appellate court?
So I'll read it. I'll read this judge. May I read this judgment, Lordship?
What is that relevant part?
From, I think, page 95. I think, Lordship. Page 95.
Yes.
Page 95. Paragraph 6. Middle.
Okay.
Now, the question that requires to be answered in this appeal is whether the impugned judgment and order dated 22/2/2018 is sustainable in law and fact of the case. I have carefully examined the impugned judgment and order dated 22/2/2018, the memorandum of appeal, the evidence and the documents on record, and after hearing the arguments advanced by the learned counsel for both sides, give my decision as follows. The learned counsel for the accused vehemently argued that the learned court below erred both in law and fact in passing the impugned judgment and order dated 22/2/2018, inasmuch as the prosecution has failed to prove his case beyond all reasonable doubt. Further, when the trial court, after absolving the accused from the mischief of section 468 and 471 of IPC, he could not be convicted under Section 14 of the Indian Foreigners Act 1946. Therefore, the learned counsel for the accused has submitted that the impugned judgment and order is liable to be set aside and quashed and is barred in law. Counsel for the state respondent agreed with the submission made by the counsel for the accused and submitted that the prosecution have failed to prove the case beyond reasonable doubt. To understand the rival contention, let us discuss the evidence on record. PW1 had deposed that Mr. So-and-so, a Nigerian, reported his arrival on 5/9/2011 and at the FRO office Shillong. Then he got himself registered by registration number so-and-so dated 06/09/2011 and his visa expired on 17/10/2011. Then on 12/9/2011 he left Shillong for Guwahati and then he reported back to FRO office Shillong on April 2012. On checking of his visa, it was found that his visa was extended by the Assistant Foreigner Regional Registration Office, Delhi, till 16/10/2012, by memo number MHA so-and-so, dated 15/10/2012. It raised doubt as because his visa was extended till 16/10/2012, and the date of his granting of his visa is on 15/10/2012, 1 day prior to the expiry. Then on 17 April 2012, the office seek a clarification.
Yes, can you pause for a moment? Now, that is an admitted position.
No.
That the extension was till 1610.
Yes.
And it was granted on 1510.
Yes.
Okay. Now, his visa expired otherwise on 17/10/2011.
2011.
So, can it be something like the extension of visa with retrospective effect or something like that? Can it be something like that?
That extension which he obtained, that one, Lordship, it was still up to 16/10/2012. This extension, the second extension, this is a.
Is it not required for a foreigner to have that period extended before his stay begins here? Can it be something like that? A person remains here and gets it extended subsequently.
It should be the extension. It should be after
See,
the expiry.
After the expiry of visa, even 1 day stay is illegal, rendered illegal, isn't it?
Yes.
Now, the court query is that from 17/10/2011,
2011.
His
Visa expired.
And immediately he did not have any extension order
Yes.
at that point of time.
Extension should
According
be
to
done.
him, his extension up to 1610 was issued to him by on 1510.
1510.
So can it be something
It
like
cannot
that?
be, Lordship. It should be done before the expiry.
That is quite interesting.
At least 1 week, or even if 1 day or 2 day also. That will.
That is exactly the query of the court.
Yes. But after that,
Illegal
it's not possible.
illegal stay, can it be legalized by a subsequent this thing?
No,
Extension
it
of
cannot
visa?
be done like that. That also it cannot be done. It cannot be legalized by a subsequent extension.
Where can we get those related provisions?
That illegal stay, it cannot
In
be
such a
legalized.
case,
after the-
even if he has
Yes.
extension, okay,
Yes.
then his stay will be illegal.
Yes.
If it cannot be from retrospective effect.
Yes.
Was it issued on 1510?
Yes, my lord. It was in 1510 only, but however, my lord, the issue before your lordship is, my lord, admittedly, my lord, my visa was up to October of 2012. I was arrested in the month of June of 2012. So I had 4 more months.
So it
What-
means a
what-
time, wait, just a minute.
Well.
Your initial visa expired on 17th October 2011.
My lord.
You arrested in month of June
Well.
2012. At that point of time, you had no extended visa.
No,
with
it
you.
was extended. The second extension is there.
When it was second extension was given. Not on 1510 as has been reflected here.
No, my lord. My lord, if I may, my lord, I may be allowed to file one bullet points, my lord, so that it will be easy. Because my friend is jumping from one page to another.
No, see, this is what has been recorded by the appellate court.
That is true, my lord, but eventually that is an observation, my lord. But what is the ratio of the judgment? The ratio is that I have been exonerated, my lord, for 68 and for
See,
70.
one thing this court has to decide that even after your exoneration, the 468,
My lord,
can you be held guilty for overstay?
I cannot be by no stretch of imagination, my lord.
What basis you say? Why you say?
Therefore, my lord, my submission is that
No,
at the time when I was,
if you can show,
my lord, I have already,
that
my
your
lord,
extension was obtained in a subsequent day,
my lord,
whether that will fulfill the requirement of law.
my lord,
It's a normal assumption, of course, subject to the correction made by UC. Normal assumption after expiry of visa, even 1 day stay is illegal.
true, my lord.
Then how can it be extended thereafter by a future communication with retrospective effect?
That has been admittedly done in this case, and there is no issue, no objection filed by the state. No action was in that regard.
No, in such a case, you see, so long you did not have your extension, your stay is illegal.
Whether that is an issue before the trial court below, my lord, is there any whisper on that?
See, you were arrested in
the month of June.
In the month of June.
My lord, and my visa was.
At that point of time,
My lord.
you had extension.
Yes, my lord. It is on record.
16 June means 2012 of 2012.
My lord.
Then how do you say that this was extended till 1610?
Yes, my lord.
But then that extension was granted on 1510.
My lord. That point was never raised in the trial court below, my lord. There is not a whisper on that.
Where is that material exhibit?
I have produced it, Lordship. It's in the record, Lordship, of your.
But then we are on a revisional jurisdiction, isn't it?
My lord.
Material exhibit is there, Lordship, before your Lordship.
No, Justin, what is the basis of this finding then? On checking of the visa, it was found that his visa was extended by the Assistant Foreign Regional Officer office till 16/10/2012 by memo number so and so dated 15/10. So it's just 1 day before.
Exactly. It was valid till then. 1 day before.
Till then means your visa expired on 17/10/2011.
My lord.
And you got this thing extension.
My lord, there are 3 extensions.
16/10/2012. Why didn't order dated 15/10, just 1 day before?
My lord.
It means your 1 year stay was totally illegal. And that stay was legalized only just, you see, 1 day before when this order was, the extension was period was to expire. How can it be? That is what you say, like this court is finding it very difficult to
My
accept.
lord, that is why my submission, which is why, my lord, I may be allowed to file a bullet point, my lord. That will make, that will bring clarity.
No, definitely you will be filing it. See, this court is not no way going to this thing. Now,
If
this
your
is a
lordship-
matter probably it was hard before also.
My lord,
What happens
number of
after-
times, my lord.
After certain gap, what happens is things doesn't remain. You see, like it goes like
Exactly.
this. Those, especially those minor points.
My lord, which is why, my lord, a written argument would
If
be.
your lordship permit me, lordship, I'll take your lordship to this material exhibit.
Where it is?
I have produced it before your lordship. It is in the record, lordship.
Can you go into that area now? No, this is evidence only.
My lord, I had been making that submission time and again, my lord. Where is the need to go into the evidence, my lord, when conclusion has been drawn, my
The
lord?
extension is there.
Just court wants to see on what date it was extended.
After that, 17/10/2011.
No, but then this material exhibit is not this thing, part of this paper book.
It is not part of this paper book, lordship.
This is a document, isn't it?
Lordship, in material exhibit, lordship, maybe this petitioner you don't have access to.
But then
this
you said you
material
produced it.
exhibit. I have produced it, lordship.
Where is that?
I have produced it, lordship. It is in the envelope.
You produced it before this court.
Yes, lordship. I have produced it and it has been kept in the custody of this court.
Was it called for?
Yes, lordship. Yes,
By-
it was called.
By this court?
By the order.
By this court?
So far, I
Material
remember.
exhibit was called for. Where is your order?
Order.
Where is the source?
Order. Hmm. 19.
That is the case, Mr. Gudung. Earlier also you filed written argument here in this case. Where are those copies of those? The office note says written argument has been filed. If a written argument is filed, why these matters are before this court now?
Exactly, Your Honor, because it was heard and reheard, my lord.
Because of the roster, it has been.
No, but then it was done before this court, this thing joined during the service. So, you must be having an extra copy of your written argument with you. Yeah, do not. You can produce it later, but then. There is no such order passed by this court, Mr. Karmi.
It's there, Lordship, it's there.
Not by this court, at least. Not by this court. If it is by previous bench, where is that order?
Previous bench, yes.
And where is that, and where it is recorded that you have submitted?
I'm searching that order.
Kindly see. Now, if something is submitted to the court, it must be in court's record.
Yes, it's 773
Of?
73 of 2023.
Now, where is that material exhibit then? Where is that material exhibit then?
I have produced it, Lordship, and from that
You
time
produce it will be kept in the
it is
custody of
kept
the
in the
court.
custody of
And then?
this court. It's in the envelope, Lordship.
It is something there in the envelope.
Yes. This is the one, I think. This one.
It is sealed. Is it sealed?
That is the passport, and the visa is pasted in the passport. Visa. This extension, the extension which is valid. The extension which is valid up to 7.
Now, when he was arrested in the month of June,
yes,
was it produced?
He reported in the FRO official law, and on examining the this visa, Lordship, it is found there are some doubts, some discrepancies. So therefore, a clarification was sought from the FRRO office, Delhi.
Very interesting. It shows extension only on 1510.
The one which was
check
valid.
in the provisions whether that can be done or not. That means it is something like you are legalizing the stay of a person who otherwise was staying without. This is up to 1710.
The first extension up to 1710. This is all right.
Okay,
but the second extension on the next page.
There is something. There is something.
There is no extension number.
Wait. Even fast extension also, you see. This is 1710. But then it was done by a memo dated 1510. So there is nothing wrong in it. So that is the practice, I think.
1510 2010.
Yes, and before that you just see extension number so and so, date of issue is 1810-2010.
Date of issue 1810-2010.
Yes, so after 1710.
Then after that extension.
Stay was up to 1710. Extension was up to 1710. Oh, 2011.
Yes, 2011.
Yes, Mr. Gurung, something is there to be clarified.
Seal is also
something
different.
would be required to be clarified here.
Seal is different. There is no endorsement of the FRO office law, and the.
My lord, this is a complete mockery of the court, my lord. He is comparing the seal right now, where a conclusion has been.
See, we are not on seal and all those things.
My lord, kindly come to the evidence, my lord. Not even the original seal, which is alleged to have been forged, my lord, was never supplied to the official.
We are not going and altering this thing. You see that finding. There is no question of going into it.
Oh, what my Lord
We are just going for the admitted thing. We are not treating as forged. We are treating as original. But then, if you take it as original, what comes to the mind of the question, the mind of the court is that, the question which comes to the mind of the question is that, if your extension was till 16/10/2012, could it be extended by an order dated 15/10?
My respectful submission, my Lord.
See, just refer to your previous extension. The previous extension was up to 17/10/2011, but then it was extended by an order dated 18/10/2010. That is what the normal thing, that before the validity expires, it has to be extended. Now, in your case, your validity expired, you went on stay, and just, you see, before your expiry of your alleged extended period, just one day before, your extension order has been issued. Now, what is the, you see, like in such a case, your stay in the month of June and all, when you were staying there, it was illegal. We are going by it. We are saying that it is correct. We are going by it.
My Lord, my limited submission would be, my Lord, this was never brought into during the trial, nor it was challenged, my Lord, in any way.
I don't know, something now, this has to be seen whether there can be a retrospective extension of visa.
My Lord, I may be supplied with a copy of my Lord, this.
Exhibit, you have not seen the exhibit.
No.
You can see it by yourself, you can see and return it. There is no problem.
I want a copy of it, my Lord.
You have a Xerox copy of that?
I'll give him.
There is no harm, give him a copy of
Yes,
it.
yes, I'll give Xerox copy.
Mr.
Xerox copy.
Please, just enlighten us on those things. We are not going on forgery part. Never remain and convince these things. We are only deciding whether your stay beyond that prescribed period was illegal or not. Okay?
My Lord.
Or if at all there is any extension, here it can be treated as a valid extension. Don't go by the question of forgery. We are going by the admitted thing.
My Lord, other aspect is we are in revision, my Lord.
You see, even the perversity and all, divisional court definitely can go into evidence and all. That's no problem.
Hence, my Lord, my prayer for filing written document.
Now you can always say supposing if the conviction of the trial court is based on one thing, and if whether that conviction can be sustained based on some other ground by a higher court or not, that also can be a point of argument.
My Lord.
True. Now things are taking a different shape. You see, if we go by submission, your submission all, it is very clear. If allegation of forgery doesn't stand, then the question of, you see, saying that this visa is forged will not come. Okay, we are overlooking it. We are saying, okay, we are not going to forgery. We are saying that there is no forgery here. It is correct. We are treating it to be correct. Then in such a case, since you said, or the admitted fact is that visa expired on 17/10/2011. You were caught in the month of
June
2012.
My Lord.
And your extension came only in month of October.
My Lord, I may be supplied with a copy of this.
So
I can give quality.
Because that
assistance.
itself, and if these things are admitted, then go on, then we cannot interfere with this thing, the conviction.
Right.
Then in such a case, if there is no provision of retrospective extension, that part you have to take clear. You may make a case for interference on other ground, but on this ground, then again things become quite difficult. When can you?
The copy.
When do you want it?
A week time, my Lord.
If you want, you can see the original thing.
No, my Lord, I'll
I have it here. I have Xerox.
Xerox is clear.
Copy. I'll Xerox. Yes, it's clear. I'll Xerox one more.
Please Xerox and give it. You did not see it in the trial court, at the stage of trial.
My Lord, yes, of course I had.
I do not know. This is. I thought that there is some mistake in the recording of the appellate court. But then it appears to be correct. So, what is the document is concerned?
My lord.
Okay.
One copy I have now, Lordship, for my colleague's satisfaction. He can compare it right now with the original one also.
No, then I'll see
Then I'll
like
supply it later on.
I don't think you will need to compare it.
Okay.
If you require, he can do it.
Lordship.
Okay, that will be always open for him.
Yes.
You can do it on the next day. Just supply him a copy.
Yes, yes.
I don't think as a prosecutor you mislead the court, you see.
Yes, Lordship.
That is not your job to do.
Yes.
Okay.
I'll supply.
Heard the learned counsel for the parties at some length. Mr. R. Gavan, learned counsel, paying for the petitioner submits that a copy of the material exhibit 1. A copy of the exhibit marked as material exhibit 1. But then you see, you are not given it at the time of this thing. You must have been given.
No. It was never provided to me.
How can you proceed with the trial without this?
My lord, that was exhibited. That I know. I had examined it.
No. Copy of the material exhibit was never given to you.
No, my lord.
Only the Caesar list.
Caesar list was given to me, and
what
there
is
was
it?
no application made under 207.
No, you just say, do not say a copy. You just say the copy just say the material, just say Mr. So and so learned counsel for the petitioner submits that the material exhibit 1, basic in which the charges under 49 Act was proved against the petitioner is a vital document, and a copy of the document may be provided to him before the matter is taken up for final disposal. Stop. Mr. Karmi, learned
Additional PP.
Appearing for the state. In his fairness, agree to supply a copy of the same to the counsel for the petitioner. During the course of the day.
Yes.
Stop. Yes, prayed for by the parties. Release this matter after 1 week. Get it from this.
Item number 8.
My lord, here the affidavit has been prepared, my lord, but I'll pray for some time, my lord, because will have to be signed.
This is for filing of affidavit by the
Yes,
state.
my lord. This court has granted permission, my lord.
Okay, Mr. K.P. Bhattacharya, learned government advocate, appearing for the state respondent, please grant of further
My lord,
2 weeks
2 weeks, my lord.
time for filing of affidavit by the state. The prayer has not been opposed by the learned counsel for the petitioner. Accordingly, release this matter after 2 weeks.
Obliged.
Item number 10.
My lord, I may be allowed to withdraw this petition, my lord. I don't want to pursue the matter. I want to withdraw it.
Yes, Mr. A.S. Siddiqui, learned senior counsel, appearing with signs, submits that petitioner does not want to press this application and would like to withdraw the same.
My lord, I appear for 1, 2 and 3 state respondents.
5 for 4, madam. Okay. Just record their name and say they appears for this. So, come on, prayer allowed. The writ petition stands dismissed on withdrawal.
14.